Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello, and welcome to Devine Intervention, shedding light on Illinois property tax with your host, Nora Devine. That's me. I've been a property tax attorney in private practice since 2005, and I've developed a statewide practice in all jurisdictions in Illinois, representing all property classes. Today, we're taking a closer look at some recent prosecutions in the property tax assessment space. We have brought back a popular guest, John Mitchell, to the show. John's an attorney with the law offices of Wilkie, Farr, a large New York-based firm. He's in their Chicago office, and he notably achieved an acquittal in one of the most watched cases of the last few years. And his client was John McClain, and there was a recent prosecution that was somewhat related to a property tax attorney who was brought up on public corruption charges. And John's also been following some other notable cases closely in the property tax space, and we brought him back on to talk about them. John, welcome back to the show.
Thanks a lot for having me. It's great to be here.
Can you give us another just short recap of what was the public corruption case about where you obtained the acquittal on behalf of your client?
Thank you. So we represented Mike McClain. I was co-counsel with Patrick Cotter, who's a longtime criminal defense lawyer and, like me, a former federal prosecutor. And at the case itself, which many people are probably familiar with, the two defendants were Mike Madigan and Mike McClain. And at the conclusion of the trial, there was actually a hung jury with respect to Mike McClain. Mike Madigan was convicted of several crimes, but subsequently the government decided to dismiss the indictment against Mike McClain. So there was the one trial, there was no retrial, and it was a great result for Mike McClain. We're really happy with it.
Wow, congratulations on that win.
Thanks a lot.
And you've been keeping an eye on a couple other property tax cases that were making their way through the system. Which ones were those?
Yeah, I'm really interested in public corruption matters generally, and there was issues that were in my Mike Madigan case that were specific to state legislators and to specifically with Mike McClain. He was a lobbyist, and so the interplay between lobbying and state government officials and federal law and what's prohibited and what is not. I've also been following, as you said, some cases that involve the assessor's office and assessor's office employees. And a good friend of mine, her name is Gabrielle Sansonetti. She's a dynamite criminal defense lawyer. She was one of the attorneys for a defendant whose last name was Mitskova. The list of names in this case are challenging, but the issues are similar to what you see in a lot of public corruption cases. And in that one, that defendant, he was not an assessor's office employee. He was a person who had needed some help from the assessor's office. And the allegations in the case were that he had provided free rounds of golf to assessor's office employees, and that doing so violated federal law, specifically 18 United States Code Section 666, which, as we've talked about before, Nora, is the bread and butter and the go-to for federal prosecutors who are seeking to combat public corruption by state and local employees.
So this was a private property tax payer. He owned private property. Sounds like it was commercial property.
It was.
And somebody says to him, hey, why don't you take me and a couple other people who work at the assessor's office out for a very nice, expensive round of golf sometime? And he did then, or?
He did. So he had a friendship with an assessor's office employee. And the government's allegation was that Mitskova, the defendant in that case, he had provided free rounds of golf to that friend and others at the assessor's office, as I understand it. And it was allegedly in exchange for favorable treatment by the assessor's office. And as we talked about previously, between the time that the case was indicted and the time that the case went to trial, there was an intervening United States Supreme Court case. And that was United States versus Snyder. And that case made it more difficult and narrowed the scope of United States Code 18 U.S.C. 666.
And this is the one that you mentioned last time that was from LaPorte, Indiana, and there was a contract, say it was for garbage removal or something like that, and the contract was granted to a certain vendor, and then long after, or not long after, but well enough after that happened, the mayor went to that vendor and said, hey, I hope you're enjoying the contract that you got from the city. Why don't you give me like X number of dollars or something? Is that
Yeah,
is that
exactly.
pretty much what happened?
Exactly. So what the Snyder case did was it was significant for two reasons. One is that it distinguished quid pro quo bribery from gratuities. And as you know, but perhaps maybe some of your listeners do not, the difference between bribery and gratuity is that a bribery is an agreement beforehand, and a gratuity is a gift after the fact. And so bribery would be, hey, I will give you this contract for garbage removal in exchange for you paying me $100,000 on the side, at a later date. So the payment of the money doesn't need to come before the official act by the government official, but there has to be an agreement in place beforehand. So again, hey, I'll pay you money if you give me this contract. And now a gratuity is the official act happens, and then after the fact, there's a gift by the recipient of the official act as a thank you for the official act. And previously, both gratuities and briberies were prosecuted successfully by federal prosecutors under 18 U.S.C. 666. This United States versus Snyder case got rid of the gratuity part of that.
Since I spoke to you last, I've been giving some thought to this, and I thought this was about like a zoning change or something, like a one and done type thing where it's like, oh, you need zoning, you're trying to do what you're trying to do, you need this one time only government act. That's what I thought the case was about. So I thought that I didn't question whether the court had that right at all, but now that you tell me it's about a contract for government services that's presumably for a fixed period of time and presumably renewable at some point in the future, that makes it more clouded for me. I mean, do you think the court got this right?
Well, I know it was good for clients that I represent in public corruption cases, that's for sure.
So yes, you like it.
And the other big piece of it was that the court, the Supreme Court in Snyder really clarified that what 666 targets is quid pro quo bribery. And prior to that, there were, the statute itself says intent to influence. And so that was a lot squishier. When someone offers to bring an assessor's office employee out to the golf course, in theory, at the very least, they are intending to influence that assessor's office employee.
Or at least create some kind of a positive association, even if they don't discuss the specific case, right?
And so perhaps in the future, he has an ask that he needs to make, and perhaps by building up that trust and building up the relationship during a 6-hour round of golf, then, the person will be more receptive to the ask because there's this trust that's built up, as opposed to, a straight up, here's a duffel bag full of cash in exchange for an official act. To many people, to many of your listeners, I suspect they would think that both of those things should be illegal. Both giving gratuities or taking folks out who you're going to in the future have official business in front of, that strikes many people as corrupt and inappropriate and the like. And there's something to that, and I want to talk about that a little bit later. But what's the Supreme Court did in this United States Snyder case is that they clarified that for the purpose of 18 U.S.C. 666, for the purpose of defining bribery under that statute, what is illegal and what is not. What is illegal is the bribery agreements, meaning the before the fact specific quid pro quos, not gratuities.
So, did you look at the transcript or talk to the lawyer? What was your sense of how this trial went through, and what was the testimony like, or do you have any details?
I do. Yeah, 3 assessor's office employees, or actually 4 assessor's office employees testified. one of the assessor's office employees was simply a fact witness to talk about the mechanics of how the assessor's office works. And the other three, at least the other two of the other employees from the assessor's office, they were folks who were testifying as government witnesses. They had gotten in trouble themselves, and they were testifying based on as part of their cooperation. That's my understanding of it, and I know that essentially their testimony didn't come out as cleanly as perhaps the government had hoped. And I really believe, and from speaking, from my observations of the case and reading up on it, I really believe that the Supreme Court's decision in United States versus Snyder, the fact that there was a really clear decision from the court that said there's got to be evidence beyond a reasonable doubt of a quid pro quo, a this thing for that thing, as opposed to something more ephemeral, something like, hey, there was a gift and that could have been tethered to the official act. There needs to be proof beyond a reasonable doubt that this was an exchange of two things. And I really do think that changed the outcome of the case that I worked on. And I think it changed the outcome of the case.
And there's intent anyway. Like, even without the Supreme Court case, there's intent in the current version of the bribery statute, right? And didn't you say that you thought this case might have turned a little bit on whether or not this property owner actually had the intent to influence any specific thing, or did that come out? It's
true. And so whether the outcome would have been different if it had been under the old law where it's intent to influence and or just simply pure friendship, then I think it would have been a closer call. But certainly there was arguments to be made that it was simply friendship. I don't know the details of the exactly how long the assessor's office employee and the citizen who was the defendant in the case, who was a private citizen. I don't know the length of their relationship and the like, but certainly you'd have great arguments if you had a long-standing relationship. You played golf with this person all the time, and there was an argument or an allegation by the government that this particular round was an exchange for favorable treatment by the assessor's office.
So would it be enough to just talk about this specific case during the round, or what would be the buzzwords that would be enough at this point for the federal government to be able to use the bribery statute after that development?
So they're certainly not limited. The government is certainly not limited to cases in which exclusively there's a written agreement or an oral agreement where it's, hey, it's this thing for that thing. It's always going to be the facts and circumstances. But if what's, I'll just use my case as an example. The case that I worked on where we represented Mike McClain successfully. He was a lobbyist, and the Illinois lobbying statute specifically says that what lobbying is, it's efforts to try and influence public officials. And so you have the Illinois statute, which says intent to influence is not only legal, it's constitutionally protected lobbying.
It's expected. It's his job description, right?
Right, exactly. And then you have the statute for bribery, which says that intent to influence, if you do so corruptly, which gets down to your intent, then that is a violation of the statute, and that's criminal bribery, punishable by many years in prison. And so, while not applicable necessarily to the assessor's office line of cases, or this Mitziga case in particular, the idea that you have a lobbyist who's acting with intent to influence as codified in Illinois law, and you juxtapose that with the 666 bribery statute, it makes it complicated. It makes it better for me to be able to argue and point out that what Mike McClain in this case was doing was legal lobbying, and that's what he believed he was doing. That's what he intended to do. And so proving beyond a reasonable doubt that he did not, that he instead was trying to engage in quid pro quo bribery, it was belied by the evidence and the facts in the case. And I like to take credit.
In the case of the private property taxpayer who took the assessor's employees out for golf, he must have been on the stand himself, right, to explain his intent or lack of intent.
You're absolutely right. And so he did take the stand. He testified, and he said, my intent was never to engage in any kind of agreement or exchange. Sure, I was trying to build a relationship and maintain a relationship and build trust, but not engage in a quid pro quo bribery. I didn't think I was doing anything wrong. I told you, I hinted at the fact that some of the government witnesses, when they took the stand, through really effective cross-examination by my good friend Gabe Sansonetti, who's, like I said, a dynamite criminal defense lawyer. She, through questioning, pointed out that the witnesses from the assessor's office, while they had some initial statements and initial testimony that suggested this understanding of an exchange and this understanding of a quid pro quo agreement, but they backed off of it on cross-examination and said, I'm not sure that he said exactly what I had said on direct examination. So it really is a matter of, can the government prove beyond a reasonable doubt, based on all the facts and circumstances, that there was this intent by the person who gave the gift, that there was an exchange of that gift or thing of value
in advance.
For an official act.
Historically, I always thought that the big fish that they wanted everybody to prosecute and get a conviction of was actually the public official themselves. Isn't it kind of unusual that this one seemed to be the other way around, where you have the public officials actually cooperating and testifying against a private citizen? Isn't it usually the other way around, where it's the private citizen that is cooperating to try to gain a conviction of somebody that's in office? Or am I...
It's a great observation. I will say this, that there's a little bit of everything. I think if the prosecutor could draw it up and have the case play out exactly how he or she wanted to, I think you're right. I think it would be that the focus would be on the public official and holding that person accountable. But there's many cases where the public official will cooperate against other fellow public officials and bribe payers. And so in this case, it was they were able to build an independent case against a assessor's office employee or several of them. And by way of that, those folks cooperated to presumably explore cases against other potentially or allegedly corrupt public officials, but also potential cases against bribe payers. And this particular case that went to trial was one involving an alleged bribe payer. Obviously, it didn't work out for the government, and for reasons that we've discussed. But that was how it all unfolded. And whether they had cooperated and made up cases against other, or attempted to make cases against other assessor's office employees, is something that I don't know.
So even if there's an acquittal and a happy ending, ostensibly, what are the less obvious costs of going through something like this?
Yeah, it's a great question. I really put it into three buckets when I think about it. One is, can you be convicted of federal criminal bribery and put in prison for a particular type of conduct? Another, though, is can you be accused of that, and can a case be brought against you? Could you be the subject of an investigation of potential bribery? And then the third is that there are other laws, local and state laws, that kind of capture this type of conduct. And so we talked about if you are indicted and you go to trial, and why the Supreme Court's decision in United States versus Snyder may be helpful to really narrowing the scope of a federal prosecution and having the government really focus in on the fact of whether there's proof beyond a reasonable doubt of a quid pro quo. But what about if you just get indicted or you just get under investigation? The amount of stress that you'll feel in your personal life if you are even under investigation, let alone indicted, is enormous. If you are indicted, the legal fees, and even if you're under investigation, the legal fees are going to be hundreds of thousands of dollars. You go to trial, well in excess of $1 million potentially. And so there's this huge cost that you don't see necessarily in the headlines or in the articles about when there's an acquittal. And then the third is that, we've talked, Nora, about the fact that there are state and local laws that prohibit gratuities. Now, the federal government is not allowed to prosecute gratuities following United States versus Snyder, but those laws, local and state laws, are on the books, and they can be used for among other reasons, they can be used by federal prosecutors to show that you knew that you were doing something wrong when you accepted a gift because of the existence of those local or state gift ban acts.
Yeah, I see what you mean. So yeah, you have this gift ban ordinance and you think it won't mean anything federally, but it actually can create this presumption that they can use in a federal case.
And let me just, I was just going to tell you, Nora, how they used it in the case that I tried involving Mike Madigan and Mike McClain. And in that case, they argued that both Mike Madigan and Mike McClain knew that when what they were doing was wrong, when there were jobs that were recommended and given to certain Mike Madigan associates, and they knew what they were doing was wrong because they knew that there was an Illinois Gift Ban Act that prohibited anything of value going to a elected official, a state elected official, in excess of $100. And the jobs, as the government argued, were a thing of value that were going to a third party, but were a benefit to Mike Madigan. And therefore, the gift was not something done innocently. It was done with a corrupt intent. And so the Illinois Gift Ban Act showed up in a federal racketeering and 18 U.S.C. 666 case.
All right. Well, thank you for coming on the show. I know you wanted to get to another case. We'll have to do another episode on that later. And thanks for everybody who joined us today for Devine Intervention, shedding light on Illinois property tax. If you ever find yourself at the receiving end of an inquiry or an indictment, John Mitchell's one of the best, and you can find him at the local office for Wilkie Farr. It's a New York-based firm, but they have a big Chicago office here. And if you enjoyed this episode, you can like and subscribe. And if you ever need help with any of your property tax matters, you can always check out our website, www.thedivinelawgroup.com. And you can find us and subscribe to our podcast everywhere that podcasts are distributed. And we look forward to seeing you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.